Good afternoon, everyone. My name is Jen Hicks. I'm the Director of Communications and Outreach with Maine Woodland Owners. We're a nonprofit organization that focuses on the state of Maine and provides services and resources and expertise to people who own woods in Maine, families mostly. We've been around since 1975, and we are today going to be providing a presentation on legacy planning through bequests. It's one of those topics that we haven't had a whole lot of conversation about as an organization. However, we've been beneficiary of some very generous bequests, and we wanted to have Howard Lake to talk to our members and supporters about what it means to think about groups like Maine Woodland Owners and other conservation organizations when it comes to developing their estate plans. Howard is, I'm going to say, not retired completely, but is has been the lead on the firm Lake and Dennison, which is an estate planning organization in Winthrop, Maine. And one of his specialties, or one of his areas of expertise, is the area of estate planning for families. And as it turns out, he's also very knowledgeable about land trusts. He's on the board of the Kennebec Land Trust, and he's also a landowner himself, and he's been a member of Maine Woodland Owners for many, many years. And I've been enjoying getting to know Howard. We're very lucky to have him here today to talk to us about legacy planning. And we hope this is a helpful tool for everyone who's got questions or is curious about how, if you've got land, what you are able to do with your estate planning and your land. So I will go ahead and pass it on to Howard right now. I am going to mute myself and turn off my video, but Howard, the floor is yours. Thank you very much for being here today.
All right, thanks, Jen. Appreciate that. So as Jen mentioned, I've been practicing law in Winthrop for 40 plus years now, and I'm of counsel to Lake and Dennison, which means that I get to work when I feel like it and get to spend a little more time outside and playing around in my woodlot too. So that's a big advantage for me. I hope we can have questions during the presentation. If you want to raise your hand or post them in the chat, that would be great. Jen can give them to me. So I hope we can have some good questions, because I don't really need to do all the talking here. To start out with, as Ben Franklin said, the only thing to be certain in life are death and taxes. So we're going to be talking about a little bit of both here, about legacy planning, death planning, wills, beneficiary designations, that type of thing. And of course, everything we do has a tax implication. And so we'll be talking a little bit about taxes. I wanted to just say that I don't want to give any specific legal or tax advice to you. I want to make sure that you get your own advice based on your attorney and tax professionals who know your whole situation and can give you better advice than I could ever give you over the Zoom. The first distinction probably should be from one of vocabulary, bequests and devises. So a bequest is a tangible or intangible personal property. A devise is a devise of real estate in a will. So we use those terms, and if you want to be a lawyer, and of course we charge by the word, so we always say we give, devise, and bequeath. 3 words are always better than 2 or even 1. But those are some distinctions. There are 3 types of bequests: general bequest, specific bequest, demonstrative bequests, and a residuary bequest. And so we'll talk about a little bit about each. The simplest is probably a general bequest. I give and bequeath the sum of $10,000 to Maine woodland owners with an office in Augusta, Maine for its general purposes. A lot of times, from an organizational point of view, it's best to let the board of directors decide where the money should go and what's in the budget, or what an additional gift would accomplish for the organization. And so if you put in for its general purposes, then it would be used for whatever purposes the board of directors would choose, and fund the priorities of the organization. You can also have a specific bequest for personal property. A lot of times, if you have an art collection, you might want to give some art to the art museum. But if you have a Pedro Picasso painting of the pine trees, you might want to give it to Maine woodland owners in Augusta. They could then sell it, or it could hang over Tom's desk, I suppose. But that's a specific bequest of a particular item. I don't think Maine Woodland will be soliciting too many of those, but you never know. It's funny, a lot of times people come to me with an outline of what they want to do with their will, and they have this elaborate list of their assets and designate who was supposed to get what, and they want their bank account at the credit union to go here, and the certificate of deposit to go there. And of course, these aren't good ideas, because assets come and go, bank accounts come and go, certificates of deposit mature and are renewed or moved. And so I very rarely would allow a client to have a bequest like this that says, I give and bequeath the balance of my certificate of deposit at defunct bank and trust. So that's not a good idea. And then, of course, every will, and this also goes for trusts, there has to be a sort of bottom line where the residue of the estate, the remainder of the estate goes. So here you can say, I give, devise, and bequeath my residue and remainder. So you can get a lot of words in there. In a number of equal shares, 99 shares to Maine woodland owners, 1 share to my cousin Vinny if living. And so instead of saying 99%, I would say a number of equal shares, 99 to Maine woodland, 1 to Vinny. That way, if Vinny didn't survive, then all of it, of course, all 99 out of 99 shares would go to Maine woodland owners. A lot of times, it really comes down to whether you want to have a share of your estate, a percentage of your estate go to charity, or whether you want a specific dollar amount. And that can be a tough thing to determine. You never really know what size the estate will be upon your demise. You don't know whether $10,000 will be just a small portion of it or a large portion of it. Sometimes I've gone to great lengths to say, well, if my estate is over $400,000, then I give $100,000. If it's under $400,000, I give $50,000. I mean, you can do some creative things like that, but it is a little more complicated for sure. One other way of accomplishing a goal is through a beneficiary designation. And you can, of course, do that by filling out a form with your IRA custodian administrator. You can do that through a beneficiary designation on a bank account. Of course, that is the same problem if the bank account is closed out or has more money in it than you expected or less money than you expected, that may not accomplish your goals. But the problem from an owner's point of view with an IRA is, of course, that in a traditional IRA, the distributions out of that IRA after your death are taxable. And so if you have a wish to benefit a charity, it's better to have those taxable distributions go to the charity. And if you have family members who may want to get other assets, you can give those without the risk of income taxes to your children or other relatives. So I think everybody should consider having an IRA distribution to charity. You can do that in a specific dollar amount. You can do it in a percentage basis. You can do it as a contingent beneficiary. In other words, you could say, I have your spouse as the first name beneficiary, but if your spouse is not living, then you could have a distribution out to the charity. And that distribution goes out to the charity, and because the charity is exempt from tax, they don't have to pay the income tax on that distribution. And overall, the dollars that go out of the estate would be maximized for all of the beneficiaries of the decedent. Does anybody have any questions at this point on IRAs or bequests? I'm happy to answer them. Otherwise, we can go forward.
Howard, I forgot, I did jump off before I encourage people to either type their questions in the chat, or I will be watching. I see the gentleman that's named Ann with his hand up. That's another way to get our attention. So if you would like to jump on to ask a question, please do unmute yourself and go ahead. In the lower left corner of your screen, you'll see that if you mouse over it, there you go.
Yeah, it's my wife's screen, so I'm not familiar with the system. David Gould. And my question is, if you wanted to make a contribution to SWAM as an example, say for $10,000 a year from that IRA, would it be better to give the $100,000 in advance at one time, or do it over a 10-year period of time, given that it might be coming from a SEP or an IRA?
So you're talking about a post-mortem gift?
No, I'm actually not.
A lifetime gift?
Mm-hmm. Yes.
Okay. We're going to, I'll get to that in a bit. Okay. But the advantage, I'll talk a little bit more about it in detail, but if you're over 70 and a half, you can have a distribution from an IRA to a charity direct from the IRA. And so that can be done year to year. And I think that would be a fine way to do it. Just you would make a request to the custodian of the IRA to make that distribution out. So instead of the distribution of income to you, and then you claiming the deduction on your income tax return, it goes directly to the charity from the IRA and can therefore not be reported to you as income at all. So there's a big advantage there. If you are age 72 now and are subject to the required minimum distribution from the IRA, then that's another advantage. So instead of taking that out and getting charged with tax on it, you can make it direct. So I don't know that it's there are limitations on that, on how much you can do as a gift. So you'd have to check on that. That can change over time. But you as long as you follow those rules, I think it would make sense to do that right out of your IRA. Does that answer it? Good. Any other questions at this point? All right.
Oh, so yeah, you could either turn on your video, raise your hand, and at any point, I'll be looking for you. Type in a message, and we're also going to have a little time at the end. People can jump in with their questions as well. So just wanted to make sure everybody knew that. Thanks.
Good. As I did mention, an unrestricted gift is the best because the board of Maine Woodland can set priorities for the funds. However, of course, you can restrict your gift in your will for a particular purpose, and then it's up to the organization whether they would want to accept that and accept the funds with those restrictions. Over the years, I've had a number of folks who want to set up some endowment fund, meaning a fund where the principal is held and only the income from the fund is distributed out for the purpose of the endowment. And that's great if there's a big gift, it's worth it, or a restricted gift to an existing fund. But the costs and the burden of setting up a small fund can be really prohibitive for an organization. And so, sort of have discouraged that. One example often are scholarship funds. Somebody might have $20,000 they want to give to the local high school for graduates to attend some post-secondary education. And sometimes the schools are set up to handle those types of things and manage them all in a bundle. But other times it really becomes a cumbersome prospect. Maine Community Foundation has some funds that are pooled like that for specific purposes. But I would discourage people from trying to do an endowment type of fund. I understand the thinking behind it, that you want to do good over a period of years, but it does create a bit of a burden on the organization and the costs of accounting for all of that and tracking it and making sure that only the income from that fund goes for the particular purpose can be difficult. So Jen and I were talking a little bit about the surprise gifts that organizations receive, not being aware of the property or of land that might be given. So you could have a devise in your will or trust, a devise of real estate, as I mentioned before, not a bequest, but a devise. So you could leave land to Maine Woodland owners in your will or trust. But it's certainly be helpful to have Maine Woodland owners see the property and look it over, do their due diligence. All know as landowners the burdens of ownership. You can have boundary issues or access problems, easements, hazardous waste in some cases, and then you may want some restrictions that you put on how the property is to be used and managed, and those things ought to be considered with the organization too. As Jen mentioned, I'm on the board of the Kennebec Land Trust, and I've told the executive director a few times, that, hey, the land trust is a major landowner here, and we got to not be shocked by some of the problems that arise, but you expect those things. It's one thing to have a 30-acre woodlot, but it's another thing when you get 5,000 or 10,000 acres that you're managing. That's a big chunk of land, and you're going to get every single issue that I've dealt with as a real estate attorney in 40 years come up at some point. So it's best to know those issues in advance. And obviously, hazardous waste situations are really serious. Access can be a real problem too. And I'm sure that, the land managers among you all have seen your share of such things. So here's some examples of some devise of real estate. So I give and devise my woodlot in the Haynesville Woods to the Maine woodland owners. If Maine woodland, now what happens if they don't want it? So we say if Maine woodland owners does not wish to accept this land, then I devise the property to my friend Dick Curlis of Nashville, Tennessee, if living, and if not, then to his issue, which would be children and grandchildren. So you would want to discuss that before you put it in your will or trust. You want to discuss that with Maine woodland owners so they can be comfortable with it. You may want to, you always want to have a default so that if the named beneficiary of the devise isn't able to accept it, you want to have a provision as to where it would go if they didn't accept it. You may want some restrictions on it. I put in an example there. I don't know if Maine Woodland has any properties that are restricted, but you can put in some restrictions that would be, here I've given an example, that be managed for production of forest products, never be developed. And you can even name it as a memorial to your family or whatever. One thing to consider, and especially in the conservation land trust world, rather than the sort of working landscape world of conservation, it's important to think about stewardship of the property. If you've got land that's being productive forest land, then you've probably got the stream of income over time. However, it may be that it'll be a long time before this property generates any income, and so it might be useful to have a monetary bequest to the holder of the property, so that they can take care of it until it does become income producing, because there are still taxes to pay and boundaries to maintain and staff time to monitor it. So that's something to consider it. One thing I remember, I spoke at a SWOM at the time workshop on planning for your woodlot some years ago, and I was wearing my land trust hat, and I talked. Somebody said, "Well, what if the land trust goes out of business? What do we do?" And before I could answer that question, somebody else jumped up and said, "Well, I'd rather give it to the land trust than trust my good-for-nothing kids with that property." So that guy was willing to take his chances that the land trust wouldn't go out of business. But that's a good question to ask when you're giving your land to the trust. What happens? How strong is the organization? How solvent is it? What would happen if this property, if the organization did run into trouble, and if there are some restrictions on it that could make it assured that it wouldn't ever be developed, but could continue on as you and be managed the way you want it. Let's see. Some other examples of devise would be a piece of a home. I give and devise my home in Augusta, land and buildings to Maine woodland owners. So sometimes a property wouldn't be a woodlot, but might be of some monetary value to an organization. I know the land trusts that have been given pieces of land that don't really meet their conservation goals. They may be too small or not of any significance. And in the business, that's called a trade land. It's not like it's really traded, but it's given with the expectation that it could be sold. I'm familiar with a few properties that the owners owned them for a long time, didn't really want the hassle of it anymore, didn't really want to deal with brokers and buyers and at a distance. And so gave it to the land trust and said, go ahead and sell it. And then the land trust could sell it and put some restrictions on it if they wished, or otherwise get some value that would protect other properties. So if you have a house in the city and you wanted to give it to charity with the understanding that they could sell it, perhaps they could use it as an office, but if they decided not to use it as an office, then they could sell it and to be used for the purposes of the organization. I added a little note here that it would be kind of fun and useful in the future for if you're considering a gift of land, to put together a bit of a history of management and enjoyment of the property. Some of your management goals over the years, some harvest details, and just your enjoyment of whether it's recreational use, hunting, fishing, whatever. I put a link here to a website of the Kennebec Land Trust. I'm sure you all know or have heard of George Smith, who was no longer with us, but had donated his woodlot in Mount Vernon to the Kennebec Land Trust for in memory of his father, Ezra Smith. And he put together, of course, he's a better writer than I am, but he's a great writer, and he put together a book, and you should look at it online. That's the link there. It's Walk My Woodlot, and he tells all the stories of many of the deer he shot and the critters that he sees and has seen in his woodlot in Mount Vernon. And if you're on Route 41 in Mount Vernon and want to stop in sometime and walk his trail down there, it's a great spot. So I think he had fun in doing it. He enjoyed doing it, and it's a testament to he and his wife Linda's love of the land and of Mount Vernon. I wanted to this presentation is about bequests, gifts upon your demise. But I did want to give you some disadvantages as well as advantages to post-mortem, shall we say it, gifts. One advantage, of course, is you don't have to make a decision today. If you need the money or the land later on, then you have it. You haven't given it away now. There is some risks to that, some disadvantages to that. If you don't give it away, it would be subject to creditors' claims against your estate. There's also the risk of long-term care expenses that, for better or worse, if you put it in your will and you've got claims for long-term care, then the property might have to be sold and those expenses paid. There is another disadvantage is there's no income tax benefit for a bequest by a will. And it used to be some advantages from an estate tax point of view, but with the increasing exemptions for estate taxes, both state and federal, we don't really need, most of us don't really need to worry about estate taxes now. So you do lose that income tax deduction that you might have gained if you give it during your lifetime. I know we may be getting into the weeds, but I promise you we're going to talk about death and taxes. So we do need to talk a little bit more about taxes. The standard deductions, standard deduction, as you're probably aware, has gone up considerably. And so many of you probably don't itemize deductions anymore. Itemized deductions include real estate taxes, interest, certain medical expenses, and charitable deductions. So they've increased substantially. So for this year, it's $12,555 for individuals and $25,100 for married couples filing jointly. So the advantage of a $10,000 gift to charity in a year is a lot less than it used to be, and the chances are you might not even you might be better off with a standard deduction. Another consideration is for a lifetime gift is if you give away assets and within 5 years need to run out of money to pay for long-term care, then you have a problem in the main care, or Medicaid won't pay for you until a period of disallowance of disqualification has run. So get the phone here. Sorry about that. So that's some considerations to make for lifetime gifts. One solution to that is to lump gifts in any one year. If you do decide to make some charitable gifts, it's great to do them all in one lifetime, in your lifetime gifts, to make it all in one year. That way you can maximize your advantage of taking the standard, the itemized deduction. So one way of doing that is giving to a charitable gift fund. So if you have, some Apple stock that's highly appreciated that you really don't want to sell because you get tagged with income taxes, you can donate that to the Fidelity Charitable Gift Fund. They'll sell it. They don't have to pay taxes on that. All that money, all the value of that donated gift qualifies as a deduction in the year it's given. And then it's held in an account in your name. You can't get it back, but it's and you can then parcel it out over time in that year or subsequent years as you to qualified charities as you might recommend. So meanwhile, it's earning some investment returns in that charitable gift fund. So if you wanted to take a good deduction this year and donate $50,000 worth of stock to the Fidelity Charitable Gift Fund, and there are some other ones around. You could do that, and then over time you could make your annual generous gift to Maine woodland owners right out of that fund, and that way, it might reach that same goal that the fellow who asked the question earlier might accomplish it. It wouldn't be from an IRA, of course, but it would be from, you could take a distribution from the IRA, take the income in, and then take the offsetting donation on an itemized deduction that way too. So that is another option that would be helpful. This slide was one I referenced earlier about distributions from an IRA. A lot of folks, it used to be 70.5, now it's 72 when you have to start taking money out of an IRA. It's called the required minimum distribution. And that's based on life expectancy, and it's a percentage that changes each year as you age. So regardless of whether you need the funds or not, you are required to take that money out every year. And so rather than take the money out, be tagged with income reported to the IRS, and then making a donation to charity, you can have it go directly. That way it doesn't go out to you at all. You don't have to worry about the standard deduction. And you can have it just go directly and avoid that tax reporting. My notes here.
Do you want to check in and see if there's any questions?
Yeah.
Anybody have anything they want to get clarification on? Okay. Again, you can turn your video on, put your hand up, or just type it in the chat. Thanks.
So another option here that I thought you might might not have heard about. I don't think. Well, I've been involved in the Bar Association real estate section for years, and so we've been aware of this potential change to the main probate code. We knew it was kind of going to be suggested, and a lot of us had some concerns about it because it's such a strange concept for real estate. But anyway, there were some changes made to the probate code in Maine in 2019, and you can now have a transfer on death deed. So you can have a beneficiary designation, of course, on a bank account. It's called a transfer on death. You can go into your local bank and fill out a form, beneficiary designation form, and then the name on the account would be your name, transfer on death to whomever you designated. Similarly, you can do that with a brokerage account or even individual stocks. That's been around a long time. What's new is the transfer on death for real estate. And so instead of a will provision, you can have a deed drawn up and designate a beneficiary as the person who would or organization that would obtain the property upon your death. You still retain all ownership during your lifetime. You can revoke that. You can change it, and it's recorded. It has to be recorded at the registry of deeds. And upon your death, the transfer automatically goes to the beneficiary. There are lots of complexities to this whole thing, but that's another option that might be helpful to someone. It's used a lot of times in simple estate situations where somebody might have a few bank accounts that they could designate transfer on death, and then maybe they have their home and they could make up a deed that transfers that to a child or children directly. It's an interesting concept. It's probably going to lead, like anything else, to some more litigation over it, but it's pretty well thought through. It's been the case in several other states, many other states, I think over 20 at the last I saw around the country. So I've found it to be an interesting concept, and we've done a few of them since 2019 when it became effective. So question is, what do I do next? So you talk to Maine woodland owners, you make an appointment with your attorney, and don't procrastinate. Maybe you talk with your IRA custodian about a beneficiary designation, and then you live long and prosper both. I've always noticed, people don't generally think of the legal profession as being a seasonal business, but of course, there used to be a season for real estate. No real estate used to change hands hardly between Thanksgiving and the end of mud season, but now that's become a little more year-round activity. But for estate planning, I've always noticed 2 times of year when people call to update their wills. One is in January after New Year's resolutions. And the other one is spring travel season. And in the first case, somebody says, we've got to get our wills done. That's going to be my resolution for the year. So they come see me in January. The other one is, I'm not getting on that plane to Cancun or wherever until we get our wills done. So maybe that's a good time to decide not to procrastinate. But I'd be interested, I think it's not easy to have to think about these things. It's not easy to call your attorney and make an appointment and get all your thoughts together and worry about how much you're going to have to pay for all this. So I understand there are obstacles to it. I wonder if any of you have ideas on what are the obstacles to getting some things settled, getting some things squared away. So often it's been too late. Sometimes I get a call to go to the hospital when somebody's on their deathbed, or sometimes mom and dad are to the point where I can't really notarize something for them because I don't really think they know what they're signing. And then there's the people who drop dead and, out of the blue and have never gotten around to taking care of things. So I wonder if anybody have any ideas, what are some of the obstacles to getting these things squared away? I'd be interested to hear what your thoughts are, things. But anyway, that's me, and that's what I have. So I'm hoping that you have some questions to talk about here. I'd really love to have a continued conversation.
Yeah, this is a good time for people to jump in. And there's Howard's phone number. He said he would be open to having people be in touch. And also I wanted to mention that Tom Doak, our executive director, would be very happy to talk to you about any questions or thoughts you have about your estate planning and your woodlot, or anything that you wanted to consider as in support of what we do. We're pretty new we haven't formally reached out to our members about this in the past. This is pretty new for us to get into this topic, as I had said before. So one thing that will help us is to hear from this group about where you are, what made, obviously you've thought about this because you're here today. So your thoughts would be really helpful for us. We have also Peter Jones, who's our development consultant, is on this call as well. I'm sure he's taking some notes. So if you want to if anybody who has a thought, want to offer their story right now, you can unmute and turn on the video if you'd like. There's Larry. Do you want to jump in, Larry?
Sure.
Great.
One of the questions that I've always had is, if I were to consider donating my land to Maine woodland owners, but I want it to stay as a sustainable forest, does it make sense to put a conservation easement on the property in advance of the donation?
Howard, you want to
Good.
jump in?
Yeah. So there are a lot of advantages to a conservation easement. First of all, there's a specific enabling act for conservation easements that make them nearly bulletproof from attack in the future. Now, if somebody puts a deed restriction on a deed, it's not unknown, not that uncommon to have a court lift that deed restriction. And there are quite a few legal theories upon which you can lift a restriction on a deed, that it's makes the property unmarketable, is unreasonable restraint on alienation. You know, there's all of this body of law on how to turn it aside. Conservation easement has an enabling act and gives the Attorney General the right to intervene in anything like that, in a termination. So from that point of view, it's a good way to do it. If I donate land to Maine woodland owners during my lifetime, and I put a deed restriction on it that says this property shall never be developed, shall always be kept for sustainable forestry. And then I go to take a deduction, tax deduction for that. The appraiser is going to appraise the property as a woodlot,
Right.
because it can never be developed.
Mhm.
So instead of $100,000 deduction, I get a $30,000 deduction or whatever. However, if I put a conservation easement on it and donate it, then, or the organization puts a trust provision on it, that's another option that they can put a trust dedication on it, then I've given away everything, and I'm not retaining the rights to enforce that in the future, but it invokes the Attorney General, and you're giving away all of your rights, and you get the full $100,000 deduction. So sometimes a conservation easement is granted during lifetime, is given during lifetime, and then the fee ownership is given upon death. It used to be that merged, those two things merged, and you ended up with no conservation easement. But the statute in Maine says very clearly now that it's still subject to the restrictions in the conservation easement. So sometimes the same organization owns the fee and holds the conservation easement. Sometimes those are different organizations that could do that. So yeah, and you know, I love the term sustainable forestry, right? We all know what that means, do we? It's one of those great concepts that lacks definition. So one advantage of a conservation easement is it goes into great detail, and having drafted a lot of those myself, people are fairly surprised to see 25 or 30 pages of conservation easements, which is a lot different than there shall always be sustainable forestry, you know? So it's a good thing to really think through it all and have that easement on the property for tax reasons and just for enforceability in the future.
Right.
Good question.
Thank you.
There is a question in the chat. Is the transfer on death subject to probate? That's from Ron. Ron, if you want.
No, it isn't subject to probate. That avoids probate. Exactly, it avoids probate, and so that's why I say in a simple estate, you can have your bank accounts designated as a benefit with a beneficiary. Your life insurance would have a beneficiary, of course, and your real estate now can go transfer on death and avoid probate. So I do have to say that probate in Maine is a pretty simple process. I have a lot of people come to see me and they say, I want to do a trust and I want to avoid probate. It's horrible. And, you know, my cousin's brother's sister, wife had a problem with probate. 99% of probate is pretty simple, slam dunk, it's no controversy, no problems. And if you have a simple family situation, it should be simple too. So I don't advise people to go through a lot of gyrations to avoid probate, but for an estate of like that, it makes a lot of sense. Now, if somebody has 8 children, that can be more complicated, and leaving a property, a piece of real estate to 8 children is inviting dispute and litigation and partition and everything else. So I'm not sure that's the best answer. Maybe the best answer in that case is to say, I name so-and-so my personal representative and direct that they sell the property and distribute it 8 ways, because that's probably more realistic.
Hi, Don. Did you want to jump in?
Hi, Jen. Well, Larry stole my
You're-
question.
You're a little low. Your volume's a little low. Maybe there's a volume on your microphone.
We'll try that. Is that any better?
A little bit better. You have to just speak up.
All right. I'll fix that. I'll get on the mic.
That's- You got it. You got it.
I need coaching. I've been on a lot of these over the past several months, but I have more to learn, I guess. Yeah, I was very interested in Larry's question, and I greatly appreciate Mr. Lake's answer to the question. It gives me a much better idea of what the options are and which ones are not necessarily good ideas. So thank you for that.
So Howard, Don is a real estate agent, and I know, Don, sometimes you're coming across a lot of these questions regarding property, and so it'd be for me kind of an interesting overlap. What do real estate agents need to know? What do estate lawyers need to know about incorporating groups like ours in estate planning or in future planning for land? Or we've actually received a donation of land. We had through a realtor recommended us because their client did want to donate some of it. And it just happened that the real estate agent had been on the board of the Nature Conservancy at one point. So they were an informed person that knew the steps and knew that this was an option. So we feel like, the more we can engage those areas of expertise in what we do, we'd have a lot more of those opportunities probably.
I think you're right. It wouldn't be a bad idea to have a brochure pamphlet that you distribute to those of us that are members that are also real estate professionals.
Yeah, we'll talk offline, Don. I'll probably follow up on that with you.
Yeah, no, I look forward to it. And I have a very special wood law. It has to be more special than anyone else's. So
I know you do.
it changes.
Don was
changes
also
everything.
the woodland, he was the tree farmer of the year in 2019. We had a fabulous event on his property. Fall of 19 was our last big event before COVID hit. So I think of it very fondly. But Don has really made it a place for people to learn and engage and get inspired. I wouldn't be surprised if there were some people who decided it was time for them to own some woods after touring your property. And I
I
know
was
that you
out
work with a lot of organizations to
day before
showcase.
yesterday. I was out showing property to some folks from Minnesota, and they were thrilled at all of the silvicultural information that I was able to pass on to them. And they said, "Did you take forestry in college?" I said, "No, but I've had over 50 foresters on my property, and so I've learned a lot from them." I've learned one thing is that no two foresters ever agree. But if you add it all up, I've learned some things.
Right.
So yeah, it's interesting. And you didn't mention, and I didn't want to mention myself, but we're down to 8 now, with me representing the state of Maine as a national tree farmer
Oh,
of
I
the
didn't
year.
know that they'd made progress on that.
Yeah,
That's
they keep
great.
whittling it down, and now we're down to 8, and we're supposed to know by June, July of this year.
Well, we certainly want the Mainer to win, that's for sure. So yeah, it would be the National Tree Farmer of the Year then. For 2020, what year would it be for?
Yeah, it's
2021?
well, it'll probably be 2021 because they shut
Mhm.
down everything in 20 because of the
Yeah.
COVID. They couldn't come out and actually view each of the candidates, and they didn't feel that it was fair to run it that way, so they moved it all ahead to this year. Yeah, so
Don, I think you make a good point. I mean, it's tough. Maine wood landowners, the land trusts are not going to conserve and steward enough land to keep Maine the way we want to see it and to keep forest land in good hands. And so recognizing that not everybody can give their land to Maine woodland owners or the local land trust, it's great to have people like you out here who can put information in the hands of buyers of woodland, so that they can be conservation owners. I mean, that's really probably where, I don't know, 90% of the conservation happens is privately with good ownership and good stewardship by landowners. What Maine Woodland can do and the Land Trust can do is certainly important, but it's really the conservation owners that are carrying most of the weight, and of course state ownership is a big thing too.
I had 3 clients last year that now are tree farmers.
Right.
And it was because of basically the first walk of the woods. And they were talking about, well, we'll harvest this parts to help pay for it. And I said, you can do that, but I can tell you that you're giving money away if you do, because it's an immature forest. I said, if you're thinking about harvesting, you're right in a growth period for these particular trees. And if you let those go, you'll end up ahead economically down the road. And so that's exactly what they did. They did no harvest. They contacted my forester and he got them a management plan through NRCS at no cost, and off we go. And that is a great start. It's how I got involved in it. I was working with a forester at Unity College, and he asked me if I was interested in that sort of thing, and I said yes. And so that's how it started 40 years ago. And so you're absolutely right. If you want to really make an impact, teach a new landowner about being a good steward of the land and where the help is and where the financial assistance is, because it's fantastic. I mean, I've used USDA and the EQIP project for now 6 years. I've been able to do things that otherwise I couldn't do. And so that, getting involved in that is a really giant first step for folks.
Yeah, and I was just thinking too that our forester, Harold Burnett, has worked with people who are thinking about donating their land to us. And he's actually offered them a 6-month, 1-year plan before you donate. So, if you feel like there's harvestable areas on your property and you want the timber sale before you donate, you could do that. I think, Howard, you were mentioning, your land's less valuable, you'd have less of a tax break probably if you reduce the value of the land. But on the other hand, if you're looking for that revenue, there's definitely different options to take to get ready for your donation, depending on what you want to pull from your land.
One of the problems with that is that I can't cut any of my trees. I've been nurturing these things. It's just like children.
Right.
I can't be there and watch them be cut. Some of those red oaks that are.
Did you name your trees, Don?
Some of them have names, and I've hugged a few of them.
That's tough.
One of the things, Jen, as far as harvesting before sale. Now, from an appraisal point of view, the appraisers don't generally look at timber value. I mean, it's pretty rare. I mean, you can get a timber appraisal, of course, in a place where the value of the trees may exceed the development value of the real estate. But so generally speaking, a landowner can do a harvest and then sell it or donate it and get the full value they would have before. Now, I suppose if they do a terrible harvest and diminish the fair market value, if they put it on the market, that's going to affect that, the buyer. But as far as a donation is concerned, usually a donation of the land followed by an appraisal isn't really going to change
It's good to know.
with some trees being cut.
I saw Larry's hand up.
And if I was doing a harvest, it would be minimal. It would be a very selective process. I just couldn't do it any other way. But that is a good idea, and I would think about that.
Mhm. Larry?
A question is, if your property is currently under timber tax, does that have any implications for transfer to the next generation or whatever?
Good one.
Well, it does, I mean, there are the requirements of a new plan to keep it in, in tree growth at the time
growth,
of
yeah.
transfer, of course. You have, what, a year, I think, to do a new plan. I suppose, and Don, you could answer this. If you're putting the property on the market and it is in tree growth, then the buyer has designs on development, then the penalty for removal would have to be factored in somehow into what the buyer is going to pay. I mean, if they know it's in tree growth, they know it's going to cost them $20,000 to get it out, that would certainly enter into the price with it. Whether it's dollar for dollar, depends on the negotiation.
If I personally listed it, it would be with the condition that it stays in tree growth.
Mhm.
The buyer has to do that as part of the transaction. And I've worked with people that have done that. They've made that clear to them in the presentation that this property is going to stay in tree growth, and so far it's worked. And if it's one like mine that has been managed very effectively for 40 years, then there are buyers out there that would love to have that piece. I wouldn't worry about it a bit in terms of market value. And it is remote enough that it wouldn't be all that easy to develop it.
Well, we've hit the 1 o'clock time. Do we have any last questions, or anybody want to jump in for a quick question for Howard? Okay, well,
So you can all call your attorney this afternoon, make an appointment to update your will.
Right, exactly.
and if you do want to reach out to Tom, our executive director, it's tom@mainwoodlandowners.org. I'm sorry, I don't have it written down. And our phone number is pretty easy. It's 207-626-0005. So you could also give them a call, but check our website, mainwoodlandowners.org, and we have all of our contact information there. But yeah, we'd love to hear from you more. I think Tom fields probably a half dozen questions a week from people who just want to talk about their property and think out loud about what's next for them, how to maintain a relationship with family members so that decisions can be made, all those things. And he's seen it all. He's great with that. So, and having Howard's expertise injected in this conversation has been great as well. So thank you, Howard, for being here and doing this for us. And the slideshow I will send out, once Howard gives me the final one, I will send it out to everybody who registered for this program on email, and I'll have this recording on our website. And thank you everyone for being here today. We have our next program on April 29th on Thursday, next Thursday. It's going to be Tom Doak talking about the legislative session and some key issues that are being discussed and introduced in the legislature that is, we think, important for landowners to know. And in May, we've got a couple programs as well. Just check our events calendar on our website at mainwoodlandowners.org/events. You'll see our calendar, a link to our calendar there. I hope everyone has a great rest of your day and take care. I hope to see you soon. Take care.
Thanks.
Bye-bye.
Thank you very much.